number that we have a few people who are probably going to be rolling in the next minute or so. So we're going to hold off for starting for just about a minute or two, and then we'll get going. Thank you. As I know, I'm the moderator. I'm also a mediator and an arbitrator here in Austin, Texas. I'm a full-time ADR after having litigated for a little over 25 years out of Chicago, doing mostly insurance coverage and other complex litigation. And I wrote an article about litigation funding and its impact on mediation, and I'll be talking a little bit about that later. But we're going to start off, we're going to go to Atlanta, where we have Rebekah Ratliff. Rebekah wrote an article, Co-Mediation as a Conciliation Tool. And before we get into your article, Rebekah, tell us a little bit about yourself.
Thank you, Steve. Good afternoon, everyone. I'm Rebekah Ratliff. I am an international mediator and arbitrator with JAMS, based here in Atlanta. I am also an adjunct professor at Howard University School of Law. Fun fact about that, I'm not a lawyer. My background is insurance. I'm a former commercial insurance claims professional for over 25 years, and I handled liability cases of all types in most of the 50 states and internationally. And then I reinvented myself as a mediator and arbitrator, and I have extensive subject matter expertise in civil torts, and I also handle some employment. So really happy to be with you here today. Thanks.
All right, well, great. Well, your submission I found really interesting, and it focuses on co-mediation. So why don't you tell us a little bit about co-mediation?
Okay, so basically co-mediation is the use of more than one mediator. That's really it in a nutshell. And the reason for that there could be a variety of reasons for that. But it's starting to take form. It's starting to pick up as a form, and lawyers work in teams. Why not mediators? So you have more eyes and ears on the process and the parties. One of the talks I had recently, I was emphasizing to some of our former judges that as mediators, obviously the role is different from an arbitrator. And as mediators, we control the process, but not the people. But there can be different mediations really going on inside the mediation that might be cause for using more than one mediator to manage the process.
Well, it's interesting. I, like you, reinvented myself to become a full-time mediator and arbitrator. And it's not the world's greatest business plan, but I moved from Chicago to Austin for my wife's job. But so I wound up moving to a jurisdiction where nobody knew who I was. So at the beginning of my transition, I did a lot of pro bono mediations at what they call here in Texas dispute resolution centers, and they're set up in counties. And so the very first one that I did at the beginning, they, as a practice, especially in family law, tried to pair two mediators and pair a woman and a man so that the parties felt comfortable. But one quick anecdote on that: the very first mediation I was paired with this woman, kind of blue-haired, 75-year-old non-lawyer, former PTA president. And we're doing the mediation together, and we got to what was a major dispute, which was there was a property dispute over the guns. And he either wanted his guns back or a monetary amount for it. And I'll admit, this was all new to me. And Pat, my co-mediator, asked him follow-up questions about what type of AR he had. And when bless your soul, that's not worth the dime more than, X, and then we got the case settled. So
There you
I,
go.
I can just say that, having a co-mediator with specialized expertise,
Yeah.
can definitely be advantageous. Why do you think it's not done, more often in the commercial context?
I think because of the sharing of the fees, the fee situation, I think that's the biggest thing, is that the fees have to be worked out. In insurance matters, which is the majority of the cases that I see in mediation and arbitration, the defense counsel sometimes, the plaintiff counsel gets them to pay the mediation fees to sweeten the pot at the end. But that's not always the agreement at the beginning. But I think mediators don't want to share their fees because either you have to split the fee. This concept is so early that uh, carriers aren't really willing to pay for two. Because and I used to handle as an adjuster, looking at the billable hours of the attorneys, and we used to cut, well, there's can be, one partner, but there needs to be associates working if there's a team headed towards trial. So it's kind of the same concept. Carriers don't want to pay for two mediators. So ideally, the mediators can come to some agreement where they split the existing fee. Maybe they take the higher of the fees, and then they split them. I think that's the biggest reason. Another reason I think is because it's just not a well-known concept yet. It's just not common. So I think that as the concept catches on and people understand that you may get more equitable out, there's an argument to be made that you may get more equitable outcomes because of varied perspectives being applied to what is said and heard. We all know in mediation, what is said sometimes is not always what is heard. And that's why we have to probe as mediators to make sure that we clarify. So I think, I don't know that there's any one reason, but I think those are probably the two most common.
Well, one thing that comes to my mind a little bit, and maybe it's more of somebody who's still establishing a practice as opposed to somebody who's already well established, is I think I'd be a little bit concerned about if I'm suggesting it, then what the other side is hearing is, oh, he doesn't feel comfortable that he can do this mediation. So I'm just going to find one other person who's comfortable doing it. So what, any thoughts about how you could broach that? So
Yeah, you make a good point. And I do think that the mediator who suggests a co-mediator needs to be a person who is established in their practice and has that kind of influence. I mean, we know that there's just all these diversity talks these days about how the selection of diverse neutrals is really it's disproportionate. And so there's a case to be made for using a younger mediator who, may have special particular skill sets. I think it's up to the person, the mediator who is selling the co-mediation concept, to give reasons, to be very clear about why another mediator, one or two, might be useful. It could be because it's a multi-party case. It could be that the case is very severe, like maybe a construction defect case. Those can be very complex with lots of different carriers, overlapping policies, coverage issues. So I think that the mediator selling the concept has to be clear about why a co-mediator may, or more than one, might be useful. Because you do have to sell the price and you have to sell the concept. But it helps if you already have a reputation and people will they will act on your recommendation. That's probably where we're seeing it more commonly now, is where a mediator who already has that type of influence can make a suggestion and it's well received.
all right. Well, we're going to jump around a little bit. So, but I have one last question for you on this, go around. And that is, do you have any tips for, it seems to me that your article suggests that you mentioned construction cases, which have multiple parties, insurance cases, which often have multiple parties, that those are the type of cases that might be better suited for co-mediation. So if you and I were co-mediating, or you're co-mediating with somebody else, what are some of the ways you want to make sure that both co-mediators are providing the same message? Because it seems to me that one risk of co-mediation would be a party who thinks they heard something from one of the two, mediators, where maybe the other mediator wouldn't have said it that way, or might, somebody might have overpromised something. So what safeguards are there so that if we have two people, that they're still on the same page?
Okay, yeah, that's really important. So the mediator, who is we'll just call them the lead mediator, maybe sets the strategy. So it could be what I outlined in my article is I suggest three different ways of doing it, depending on what kind of case it is and what seems to be appropriate. But you're adding additional mediators because you want additional perspectives and skill sets to add to the mediation environment where challenges exist that might impede the settlement. So if you're the mediator that's forming the team, hopefully you know who you are recommending, and they set out the strategy. So it could be styles to manage personalities. It could be, it needs to be choreographed. And so what I suggest in the article is simultaneous shuttling, which would be separate shuttling, but the mediators need to check in during the mediation in order to, if you're shuttling, so you're separate, you're in the rooms at different times, you're not going to be hearing the same thing at the same time, but it's important for the mediators to check in. If you're a team, then you get in a huddle and you can check in. Partner parceling is maybe there's a coverage issue and the lead mediator has set it up where the co-mediator is handling the coverage piece, and that's their job. So everybody goes in with the strategy knowing what their job is. And the third format that I suggest is concurrent caucusing. So you're tag teaming, and then you are hearing the same things at the same time. But in any event, the recommendation would be that the mediators are huddling. They have a huddle, and that could be in what I call the mediator room or the principal's office, where you go in and check in and make sure that everybody's on the same page.
All right. Well, thanks. Well, we're going to go from Atlanta to New Haven right now. And so we have David Reif. And we've joked a little bit that, David, your paper out of the four, I think, was the most scholarly. You can tell us a little bit about it, but I'll start out by asking you to tell us a little bit about your arbitration practice.
Sure. My practice is primarily arbitration. I do mediations, but I think probably 2/3 of what I do, maybe even 3/4, is arbitration. I'm also a reinventee, if there is such a word. I tried jury cases for about 4 decades, and then retired from practicing law. Didn't do the off-counsel thing. I was with a larger firm. Retired, and I've been a full-time arbitrator and mediator now I'm going into my 8th year. I also taught, like the two of you, Quinnipiac Law School as an adjunct, and taught first-year civil procedure. If you want to talk about something where you periodically have to fire a cannon across the room to wake people up, it's first-year civil procedure. And this year I'm coaching their arbitration team. So my arbitration work is really on the commercial side, except I do legal malpractice work.
All right. Well, so you wrote an article about Coinbase versus Bielski, a Supreme Court case that talked about the situation where parties disputed whether they should go to arbitration. A party moves to compel arbitration. They lose. That party appeals. And what happens in the interim in the court in which you're litigating? So once you tell, it was a 5-4 opinion. The Supreme Court made a pretty clear proclamation on what otherwise was a divisive fact pattern for the lower court. So why don't you tell us a little bit about the decision?
Yeah, there was a clear circuit split. And so the issue is, during the pendency of the appeal, under the FAA, you can appeal an order denying a motion to compel. And during the pendency of that appeal, what happens to the case? And the circuits were split as to whether you could go, whether the case continues to go forward, because with arbitration denied, it's still sitting in district court. So does the case keep going forward, or does everything get stayed until you get a resolution from the Court of Appeals? 5-4, the majority held that it does get stayed, and their language is clear. I mean, it isn't just as motion practice gets stayed. I mean, Justice Kavanaugh twice talks about staying discovery. And there's really sort of two bases when they do a statutory interpretation. The second, they go back to an old case called Griggs, which says that once you get an appeal, the district court is divested of the ability to do anything. And the real one was a policy dispute. The majority said that we potentially are wasting all kinds of money if we move forward with a lawsuit, do discovery, do all that work, and then arbitration is compelling. The dissent, Justice Sotomayor, talked about people dying, witnesses being lost, documents being lost during the pendency of appeal. And it's interesting, apparently the average time, the median time for an appeal, filing a notice to a final decision, according to the administrative office, is about 10 months. And so the question is, what happens during that 10 months?
Well, so you made the shocking statement that you thought that while the courts were discussing the interpretation of the FAA and other statutes, that at the end of the day, it was all window dressing for whether they had more sympathy for a plaintiff and the delay of getting to the punchline, or the defendant for having to potentially incur expenses that they contractually didn't agree to incur because they were entitled to arbitrate. Along those lines, 5-4, Kavanaugh, Roberts, Alito, Gorsuch, and Barrett for the majority. Justice Thomas joining the liberals in the dissent. Was that something that surprised you?
It did, particularly since, and I guess I cannot really understand why. I tried to think about the reason, and I simply couldn't come up. It should have been a 6-3 decision.
But isn't it possible that he actually made his decision based on the statutory argument and not a policy argument, and just happened to fall with the liberals?
Yeah, except the issue is that he has to walk away from Griggs and the precedent in Griggs, which while Justice Thomas has been prepared to do that on some issues, on commercial type issues, he's not been a freewheeler. I mean, he's been pretty precedent driven.
Well, all of our authors are in the settlement business. We all do mediate cases. And so another interesting aspect of your article and the decision itself is how both sides talked about the impact of what the rule would be on settling cases and whether that's a good or bad thing. So why don't you tell us a little bit about how each side viewed their potential rule and its impact on settling cases?
Sure. I mean, the majority's view was that if you can do discovery during the course of the case, during the course of the appeal, you're going to run up costs, and you're going to be more or less forcing somebody into considering a settlement. Same argument, exact opposite side of the case. What the minority justices argued is that if the case gets stayed for a year, during the pendency, then you've got a situation where a plaintiff may very well have to sell out the case cheaply. So both of them made hinged their argument on exactly the same thing, and came out to diametrically opposite results. I suspect largely driven maybe by past experience, based on whom they tended to be representing coming out, based on, with the exception of Justice Barrett, based on, to some extent, whether it's academics or it's people who have been sending out bills to clients and seeing the effect on them. So that's, but that's the split, Steve. Exactly the same set of facts. I mean, it's a classic thing that mediators run into. The facts are the facts. It's exactly the same set of facts coming at it from totally different perspectives.
All right. Well, and before I get Rick Alimonti involved in this, I will say, David, we appreciated that you wrote this article for us. I think you are, I've seen on LinkedIn, a pretty frequent blogger on Supreme Court cases and other cases that impact ADR. So I'll give you a chance to give us a shout out on where we can find, more of your analysis of these type of cases.
Sure. I'm going to send out a chat that's got 4 cases that have been decided since Coinbase and that are based on Coinbase. One of them talks about the fact that it does not apply in the judge's view during a petition for cert, that once it gets done at the circuit court, that's it. The case can go forward. Another one saying that it applies only to the people who are who have sought arbitration. It doesn't apply to the rest of a class. Another one that says that it doesn't apply to an appeal from an award saying it's not arbitrable. And another one where it just applies it sort of philosophically. So I will send that out.
Okay. Well, thank you. All right. Our next author, a frequent author, if for those of you who are familiar with the Dispute Resolution Committee's newsletter, and that's Rick Alimonti. Rick, you're coming to us from New York. Why don't you tell us a little bit about yourself and your practice?
Yeah, well, hi everyone. Sorry I was a little late. I was in the middle of adjourning a mediation that had kind of reached its full potential for the day, right at about 1 o'clock, unfortunately. Fortunately or unfortunately. But so one party basically had run out of room for the day, and so the other party. So long story short, so I apologize for being late. I just didn't want to just kick everybody out the door that quickly. But yeah, I'm here in White Plains, New York. Actually, Valhalla is technically the name of this little village. I have the honor of being the current chair of the TIPS ADR committee. And my practice is about 70% litigation work, still as an advocate, and about 30% mediation, where I mediate fairly general insurance coverage, product liability, aviation, premises liability, and employment. And my mediations are fairly evenly split between private mediations and mediations as a panel mediator for the U.S. District Court, Southern District of New York. And I have a habit of contributing to the newsletter at the other end of the spectrum, the least scholarly of articles, but generally just sharing perspectives on things as they pop into my head. I do a lot of writing, both legal and otherwise, so it doesn't take a lot for me to start putting pen to paper. And so this time I just did some reflections on how mediating for the past 12 years has affected the way I conduct myself as an advocate in mediation, and vice versa. So it was just an opportunity to kind of reflect on that and how it's affected, and I hope improved, how I do both.
Well, before I ask you a specific question about your article, I think your whole article is premised on the fact that you're still mediating and advocating in front of mediators at the same time, and that dual role has impacted things. I made a decision for what it's worth, and I respect, folks who are in your position. When I was litigating, I sometimes was, asked to do amicus briefs or to identify cases, sometimes smaller cases that my clients really thought were good test cases. And so for me, I always viewed litigation as the big picture, and that every case might have an impact on another case for maybe one of my other clients. So I always felt that people like you have a much better moral compass than I do, because if I were doing both, I think I would be very concerned about, if I have confidential information about this small case, which frankly on paper might go one way, but based on the lawyers could go a different way that would help out one of my litigation clients down the road. I think that those thoughts would be in my mind, as a mediator. So just as a, as a person who's doing both, how do you avoid, having, any issues with both being a mediator and an attorney who appears in front of mediators all the time?
Yeah, well, it's really basic conflict avoidance. There's no magic formula. I don't take cases with current or existing clients or even potential clients. There has been an instance, and actually something that came up very recently, in which a former client wanted to mediate with me on a highly specialized. My main practice is aviation related, and although it's a very small, tiny percentage of my mediations, but it happened that they wanted somebody with aviation law and some technical aviation experience, and that one of the insurers is an insurer that I reported to some years ago on an airline client. And the other side had no objection to me appearing in the case as the mediator. And but I made it very clear to them that I had this past relationship, that I did not believe it would impact my ability to function neutrally. And it's going to be a very interesting case, and both sides felt confident in my ability to do it. And that's honestly the closest it's ever come in all the years I've been doing it. But it's your question is very timely, because up until then it had never been an issue at all. But the short answer, Steve, is just, if there's any potential conflict, share it. Just do everything that we would do ethically. But I'm lucky in that the niche of my practice area, aviation, does not create many opportunities for conflicts in the main areas in which I mediate.
All right. Well, one of the things in your article you talk about is, in general, who's your target audience when you're at a mediation? So why don't you tell us why that's so important and what your thoughts are on that?
Yeah, and I think it's a big important, as you know, Steve, and as we've been talking about as chair and chair-elect of this committee, is trying to teach people the difference between litigation advocacy and mediation advocacy. And one of the main differences is, if you're arguing a motion, for example, or an appeal, you're there to convince the jurists of your position, and you really don't care what the other side thinks. It's not really a factor. And it's the exact opposite in mediation. In mediation, I believe that your audience is always the other side, especially in a joint session. And I still hold to my norm is still to have joint sessions and to work with the parties on crafting them in a productive way. But if somebody goes into a mediation with the mindset that their goal in the mediation is to win over the mediator, and the hell with the consequences, that's exactly wrong. It's the exact opposite. So I'm always, I think a big key in they talk about mediators needing to have empathy to bond and bind with the parties. You have to have some empathy, and I would say considerable empathy in mediation, and it varies on the type of case. There were very emotional cases and less emotional cases, but you need to think about sort of on a spectrum as to are my remarks likely to build bridges or burn them? Am I alienating? Am I likely to put somebody on the defensive? And it's a pretty fine analysis, because certainly we're not going to come into a mediation rolling over. But you know, if our opening salvo sends the other side packing, I would argue it has not been particularly effective.
All right. Well, you also said in your article that candor pays off in mediation, and you had an example of that. Why don't you share that with us?
Yeah, well, you know, again, it pays off big time. And when I wrote the article, I had just come off a mediation in which, as part of my mediation process, I get my submissions. I try to get them at least a week ahead of time, and then I talk to the parties, and I get a submission that I can share and a submission that's for my eyes only. And it was very refreshing. It doesn't happen all the time, but it happens with some frequency that the parties' ex parte submissions were extraordinarily candid and helpful, and recognized the weaknesses of the case. And they both gave me numbers of what they thought a fair value was. And although those numbers did not overlap, this was about a $2 million case. And the difference between the high end of one range and the low range of the other was about 200,000. And so that really gave me a lot to work with. And that degree of candor when dealing just with the mediator is extremely helpful. I always assume that they're holding something back, and that's what I do. I never ask for final, last final best walkaway number, because I think that you are painting somebody into a corner by asking that. I prefer to get things like, okay, it's getting tight now, you're running out of room now, you'd have to hear something along the lines of XYZ before you'd consider moving. But when someone is comfortable enough in being reasonably candid and looking at the weaknesses of their case and saying, these are where the problems are, it's really helpful. And I understand if you don't want to fall on your sword or feel like you're falling on your sword in a joint session. But then do it in the caucus or do it in an ex parte submission where it can still be extremely helpful. And then, you can discuss with the mediator, hey, we're aware of this problem. I suspect they are too. Is there any value to sharing that we acknowledge this particular weakness in our case, and have a discussion with them as to whether that's shared information, whether you can go into them and say, hey, look, they understand there's a significant comparative fault component here, but in their view it's more here than there. So candor is, I love it when the parties are candid with me. It makes my job a lot easier, and I try to be candid with the mediators when I'm advocating, as much as I can be productively and as much as my client will allow me.
Well, it's interesting to me. You talked about getting a submission that's candid. I always make the recommendation up front that anything you tell me, you can tell the other side. And if there's anything very specific that you want for my eyes only, you can do a separate submission. And in my practice, so I'm curious, actually, for everybody here, especially, I know, Rebekah, you do a lot of insurance cases as well. I find that most parties only want to give the submission to me. And I think on one hand, they can be candid. On the other hand, for me, I've always told people, I think it slightly slows the pace of the mediation, because I assume that if they're unwilling to share a mediation submission with the other side, I don't have authority to share anything with the other side until I talk with somebody and explicitly get, that authority. What's your practice, experience on that, Rick? Do you make a suggestion one way or the other, and what do you find most parties, feel on that?
Yeah, in my mediation guidelines, I request that the parties, more or less on the same date, provide me with what I call a to be shared statement. And what that is a statement that they send to me that I will share with the other side, but I'm going to hold it until I have both of them. That way, no party gets to convert their to-be-shared statement into a de facto opposition. And I also ask for, and that's usually multiple pages, but not a lot. I try to keep it 5 to 7 pages longer in a complex case. And of course, there'll be attachments and exhibits. And then I ask for an ex parte settlement memorandum that is for my eyes only, to give me their perspective on where the settlement has been and where it could go, their evaluation of the case, and anything else that they prefer for my eyes only. So they know that when I have both shared submissions, I'm going to swap them, but they also know that what I get ex parte stays ex parte. And then as discussions continue, usually pre-mediation caucuses with the attorneys and sometimes some mixing and matching, my assumption there is that everything that they tell me is confidential, and I will only share it with the other side with their explicit permission.
Well, we have a question from Richard Mason, who is taking over from me the newsletter. We are in very good hands, but he says, what do you do when the mediation submission is perfunctory and reflects almost no work or thought?
I do my best to get a lot more substance out of the pre-mediation caucuses. I mean, it would be a little rude to go and ask for a rewrite, as tempting as it might be. And very often, the ex parte one, where you're really hoping to get some insights, is really useless. And it basically just regurgitates, it's the same numbers they've already shared, and with the throwaway that they have an open mind. That's not my idea of an ex parte statement. But really, that's where the pre-mediation calls can really show a lot of value, because, and I have, without saying I want to rewrite, I have gone back and said, hey, would you mind giving me a little more on this point? And kind of treat it as like a supplemental. And that's also something that happens in the pre-mediation conferences. Like at times you'll get submissions that are very lacking in comparable settlements, and those can be very helpful. So very often the submission doesn't have a lot of analysis on case value. So I'll go to one or both parties and ask them to supplement it. So one way around it is call it a supplement, not a rewrite.
Well, there you go. Yeah, I mean, I think I can get away with this more than our other authors, but, I find just playing dumb and saying, I'm sure, you felt you fully addressed this, but I still have some open questions about a couple things. Can you just walk me through that? Might be harder for you, Rick, because people know that you fully understand everything. But yeah, I've been fairly lucky, using that technique. And
yeah, Steve, mine is really the same. I mean, mine would be sort of the line is tell me more. I see you've told me XYZ, so tell me more about that. And the ultimate mediator open question.
Mm-hmm.
Now, Rebekah, is this a situation in where maybe a co-mediator helps? I'm just thinking through based on your paper.
Oh, sorry. I was unmuted already. Just wanted to, I wanted to add to that. So, don't really need a co-mediator to ask for more information if you need it, but I agree with Rick. The time to do that is when you have the pre-mediation calls. I always ask for a pre-mediation call. One of the things I want to emphasize, and again, I'm coming from the standpoint of a former commercial adjuster. So commercial adjusters are generally pretty sophisticated negotiators, and there's already been a plan set. And of course, it kind of also depends on the type of case, but there's been some conversations. If I handle complex cases, so there have been conversations. The adjuster already knows what they want to do, and generally, the defense counsel doesn't even know what the adjuster's authority is. So as a mediator, I'm not doing a whole lot of pushing for more in writing. Probably the brief that I've gotten or the position statement has been written very intentionally by the defense counsel. And it's my job to influence and not to try to posture. I'm the one who I'm using psychology, but I'm not in a position, I don't have any standing to really posture. And as, being a former commercial adjuster, I know how that can go really bad. Because I didn't like when mediators felt like they could push me further than I wanted to go. I was very much in control of the process. And again, my defense lawyer was, telling me the law, and I'm telling them what to do with the law. As mediators, we don't give financial advice and we don't give legal advice. So I'm very careful, especially in an insurance context, to respect that adjuster. Some mediators will pull attorneys out, pull the defense counsel out, and leave the adjuster in the room thinking, or even the plaintiff counsel may want to, talk to the defense lawyer and really disregard that adjuster who really is the decision maker. So I'm very careful, having been in that seat for so many years, about how I communicate, how I influence, and I'm very patient. So it takes time sometimes to get to the point where you can tease out that additional information you want to know. But certainly you can get a lot of additional information in that pre-mediation call.
Oh, absolutely. All right. Well, Rick, I think the last couple times I've done this, I've shortchanged myself. So
I'm ready for you.
Oh boy.
Come on.
That's a little scary, but I'll introduce myself again. I know.
Please introduce yourself, Steve.
And tell us about your article, Steve.
Let's thank you, Rebecca. I'll be happy to do so. So, as everyone knows by now, I'm Steve Schulwolf. I have a mediation arbitration practice here in Austin. David alluded to this a little bit. Like Rebecca and David, there was a 2-year period where I taught at a law school, although nobody allowed me to teach here in the United States, so I had to move to Plovdiv, Bulgaria to do that. But that was from 98 to 2000. I came back, ultimately founded a litigation firm in Chicago, and as I said, happy wife, happy life. Moved to Austin, Texas for a great job for my wife. I wrote an article
about this article you wrote, Steve.
Huh?
Can you? Steve, as the current chair, I'd like to ask you about this very interesting article you wrote on litigation funding. And I have to say, I found some of the results very disconcerting. I'd like to ask you sort of a broad question, but we all know that sort of, the end all and be all of the mediation process is self-determination.
Yes.
That's where it's the parties are making their own decisions with the assistance of the mediator to help them reach that agreement. And as I read your article, and I'll let you fill in the details, but it seemed to me that in one case, which was that I might mispronounce it. Is it let me get back to the Ezequiel, that self-determined was thrown out the window. The plaintiff was forced into a settlement that she rejected and got nothing. Is that about what happened?
Yeah, so I ran across this case. I moderated a panel for the ABA TIPS, Toxic Tort and Environmental. They do an annual 1-day seminar, and this last year it was on PFAS. Now, PFAS litigation, like a lot of mass tort environmental, is pretty expensive to prosecute. There's a lot of experts, there's a lot of science involved, and so litigation funding comes into that in terms of advocates of litigation funding say, look, you've got plaintiffs who otherwise couldn't afford to be able to prosecute these claims, and so litigation funding is a net positive. You have defendants who their view of this is that it's going to increase the cost of litigation for everybody. It's going to make things harder to settle. And as a neutral, from a mile high, I can see both thoughts. But we start running into cases. And so the case that you're talking about is City of Englewood versus Ezekiel, which was a saga that your neck of the woods out in New Jersey. And the first thing that happened, and so this was a Section 1983 action where the plaintiffs had brought suit against some police officers. There was an altercation that was captured on video. And there was a settlement conference, and I admit, when I love settlement, I'm in the settlement business, but when I was a litigator and I was in federal court, I didn't necessarily appreciate the settlement conference where I was kicked down the hall and had, another judge, look at the case. And so what happened, and there's a first opinion that's like 3 years prior, in which the opinion talks about, for a fair amount of this settlement negotiation, the clients, the Ezekiels, were out in the hall. And ultimately the judge hammered out a deal. And within a day or two before the city, municipalities, when they settle, they have to go through, formalities. So, but before it got even brought up at the next board meeting for the city, the one plaintiff said, "I'm not signing. I don't think this represents the deal." So they litigate whether there was actually a deal. And a magistrate judge looks at the evidence and says, "Yep, there was a deal." And then once that's decided, the city decides, look, we're just going to throw the money into the court and let the court decide who actually gets the money. So there were a couple of litigation funding arrangements. There were multiple attorneys involved because, frankly, after the first go around, they fired their attorneys, got new attorneys. But ultimately, the court awarded 100% of one of the plaintiff's monies to litigation funders and to attorneys. And from my perspective, what really bothered me, like you were saying, Rick, the court didn't even really show any remorse. I mean, the idea that and it was the same magistrate judge who had determined that there was a settlement agreement in the first place, then years later makes a determination that the plaintiff who objected to the settlement got nothing, so that seemed absolutely bonkers to me. And, we are, right now, litigation funding is the Wild West. Some states have rules, some states don't.
Yeah.
Arguably, some states it's illegal. I never heard the term in law school, but it's champtery, CHAMPTERY. So there's some states you can't even do it, but in most states you can. It's a $1 billion industry already. And it seems to me that at a minimum, as far as it comes to mediation and self-determination, that there should be a requirement that somebody, when they're agreeing to an agreement, and I understand that this might make settlement harder, but they should at least know what they're agreeing to. They know that what their duties, are. Rebekah, looks like you wanted to jump in.
So okay. So in North Carolina, like you said, some states have rules, some states have, so North Carolina Department of Insurance, and I know a lot about this because I was dealing with a lot of attorneys as a consultant for a time. In North Carolina, the attorney, like say a plaintiff, plaintiff counsel and their client, the client has, if they deal with a funding company, it has to be the client. The attorney can't have anything to do with it. They can't be even close to it because of that, because of the predatory nature of, this type of engagement, and because the client may not know what agreement they're entering into. They don't even really understand contingency. They don't understand all of that. What they know is they need some money up front, and then it sounds good until something like that happens. And I've heard of a situation like that. I don't know if it was the same case, but yeah, it's being handled differently in every state because it's a real,
it's different, everywhere. Now, one thing that I'll say, just from learning about this from moderating, there was 60 Minutes on litigation funding. And they interviewed, again, back to Rick, your neck of the woods. There were predatory funders who were preying on people who were entitled to payments from the 9/11 Victims Compensation Fund. And the interesting thing to me on this was the person who was representing litigation funding, for purposes of this panel, absolutely made it clear that from their perspective, there was a difference between that arrangement in which there was no risk. In other words, these people, there was an act of Congress that set funds, and these people were part of the group, and so they were going to get something. And so all it really should have been was a loan. And ultimately, the New York Attorney General went after them. But going back to at least the theoretical discussion of litigation funding, in which litigation funders are accepting risk, that they're putting up the money, they're paying the experts, from that perspective, what they would even stress in the case that I was talking about, as terrible as it was for the plaintiff, actually the litigation funder didn't get paid in full. They got paid first, and that's per the contract, and the court enforced that contract. But they didn't get paid in full, and they would say that there was, risks involved. But for me, the thing that bothered me was that the same judge who said over the plaintiff's objection that there was a settlement seemed to not, have any concerns of the fact that one plaintiff, didn't collect anything. There's another case that I talk about that, Rebekah, I'll throw this to you because I think that this would have been a case that should have been co-mediated by somebody, frankly, bringing in some diversity and to help people understand the situation. It's called Allen versus Leal. It's a mandatory case. So I did my mediation training in Illinois. And when I came to Texas, there was a requirement that I did an abbreviated, like a 4 or 6 hour, they were going to Texifies me, right? So one of the cases, Allen versus Leal, was another 1983 police shot an allegedly unarmed person at a scene of a crime.
Okay.
And so there was a settlement conference. Now, two things come out of Allen versus Leal. The Houston president of the the AAM, I forgot which one that is, Attorney Mediators Association, but basically said that what some people call bullying, others call good mediation. And it was in the context of the family at mediation agreed to settle. And then just like this other case, except they signed, but like the other case, before the city had a chance to approve it, said, no, wait, we shouldn't have done that, And the court ultimately, and this is why all mediators learn it, uphold the settlement agreement because it felt it was an abuse of the settlement process for the family to even object to it. And once you settle, you settle. So the case is really finality. The court does call out as contrary to self-determination and the Texas, mediation code, coercion is unacceptable. But what the court says, so Rebekah, I'll throw this to you. So you have a family that, again, reading between the lines, I don't know how well educated, clearly wasn't served all that well by their attorneys. But the court says something like, when you're dealing with the death of a son, we find it hard to believe that they didn't fully understand when they were settling. And for me, as somebody who's done a lot of pro bono mediations with people who aren't sophisticated, I feel that it is my responsibility as a mediator to always make sure people understand that self-determination. I can't give them legal advice. I'm not their lawyer, but I have to respect the process. And so I felt a court that said that didn't fully understand the dynamics at play in certain types of mediation, where you had a mediator who admittedly was heavy-handed, and by the end of the day wore down a plaintiff to agree, to an agreement that ultimately was what was enforced. So is that the type of case where maybe bringing in a co-mediator would help that situation?
I mean, it could be. I mean, that bringing in a co-mediator doesn't fix the mediator that doesn't understand their role. But if it's a personality style situation that you're trying to address, then a co-mediator might be, I guess I would have to know why that mediator was so heavy-handed. I mean, that's inappropriate by any stretch of the imagination. As a matter of fact, as a mediator, I say all the time, I continue to stress that there will only be a settlement if you agree to it. Self-determination, that's the beauty of mediation. But so I don't know if a co-mediator could fix the real problem, the underlying problem there. But certainly if there had been some communications prior to mediation and there needed to be some management around it, then perhaps that's the situation where a co-mediator could help. But that's very disturbing.
And
Right.
I'm constantly stressing self-determination I'm constantly stressing that and mediation.
And Steve, I maybe a question to throw out to the group too, but I'm increasingly finding when I get my mediation submissions in some personal injury cases, and I ask them to recite their liens, they include their litigation funding debt as a lien. And there are certain aspects of that are inaccurate. Number one, it's not a statutorily recognized lien.
That's right.
Two, whatever the non-interest of that portion is, it's a collateral source. So if you're gonna pay back that lien, there's a double recovery. And then of course one could argue one way or another as to whether the interest is somehow attributable to the injury, but the interest rates are borderline, usurious rates. They're typically around 28-29%. And unfortunately, they become an obstacle to settling because they can add up over time. And again, a sophisticated plaintiff looks at this debt over time as something I should get paid back, because I would not have incurred it without this litigation, forgetting that they did in fact receive a benefit of it, although certainly at an interest rate that would not have been commercially appropriate. And just to throw out another interesting wrinkle that we're getting is reports of plaintiffs' firms being a little too cozy with litigation funding firms.
Absolutely.
And where there is, if not there's something close to unethical fee sharing going on there. And if not technically fee sharing, a lot of mutual support that arguably crosses some lines. So I think this is an interesting issue that's going to have a lot of tentacles over the years to come, Steve.
And like Steve said in the beginning, the truth is some plaintiff lawyers, small firms, wouldn't be able to put on their case if it wasn't for the funding, because defense lawyers don't have that problem. The insurance company is funding it, but but the flip is it's become predatory. There's so many different situations now where the plaintiff is being taken advantage of. It's very unfortunate. It's going to be interesting as it evolves to see where this goes.
Well, it looks like states for right now are talking about disclosure as a first, a lot of states have adopted some disclosure. You hear the litigation funding industry say, look, defendants often have funds maybe from their parent company, but then their parent company is always objecting to discovery, and saying that's irrelevant. And so, they're sometimes arguing what's good for the goose is good for the gander, and different states I think are probably going to write slightly different statutes on this, and it's, definitely going to be something for mediators who mediate in multiple jurisdictions, as I think everybody here does. More and more going forward, it's going to be something that you're going to have to be, attuned to the jurisdictional nuances of that.
Yeah, it's a great point.
But all right, well, it looks like we're a little bit past, but I think about an hour after we had started. I don't think I'm missing anything from the audience. If there was anybody here who had a question for anybody, if you look at the chat, David has the cases after Coinbase versus Bielski. So for those of you who are interested in that, make sure you're aware of those. But hearing no questions, on behalf of the panel and the Dispute Resolution Committee of ABA Tips, we appreciate everybody's attendance, and we're looking forward to our next newsletter with Richard Mason as the editor. And I'm looking forward to just being in the peanut gallery next time.
That's right. You can hang up your Phil Donahue credentials for a little while.
Well, good job, Steve.
All
Job
right.
well done. Thank you.
Thank you, everyone. And thank you.
Thanks, everybody. Terrific
All
job.
right, thank you.
Our authors and editors, that what you do to support the committee. I can tell you the newsletter that's come back in great vigor over the past couple of years is really prized and appreciated by both the recipients and by the ABA tip section. They like to see us doing it. So, and I think that Steve and I have came up with this add-on of the Meet the Authors, and I think it's a ton of fun. So
That's
thank
great.
you.
Thank you.
All right.
Absolutely.